May it please the Court. My name is Alex Landback, and I also represent the Respondent, the United States government, in this action. The United States respectfully requests this Court on de novo review to affirm the 14th Circuit Court of Appeals decision and hold that Mr. Millstone was in violation of Title 18 United States Code, Section 1512B of the Witness Tampering Act for two reasons. First, corruptly persuades within Section 1512 should be interpreted with a broad construction and defined as persuades within a proper purpose. And second, a person who persuades another to withhold information for the benefit of the persuader is inherently motivated by an improper purpose. Turning to the first issue, Your Honors, corruptly persuades within Section 1512 has seen many different interpretations from various circuits, and the United States government urges this court to follow the 14th Circuit holding, as well as the 2nd and the 11th, in which they found that corruptly persuades means motivated by an improper purpose. In particular, we direct this court to the United States versus Schatz, which was an 11th Circuit case, in which in that situation, which is factually similar to what we're facing today, in which there an employer who was running a bail bonds business, he was under investigation from federal investigators, and he instructed his secretary to not speak with the investigators, or otherwise she wouldn't be bothered. And there, the 11th Circuit found that actually had risen to the level of corruptly persuading her not to communicate as per Section 1512b3.
Was she a co-defendant, co-conspirator in that instance?
Your Honor, she was an employee in that situation where she was certainly very much involved in the organization of the bail bonds business, which had run aground of many different bribery issues with federal judges, and the fact that she was very much well-versed in the business practices of this particular company, she would be a very likely source of information. And considering that the witness tampering statute itself is not just targeted at the corruptly persuading co-conspirators, but it's corruptly persuading another person. And here, in that situation, in Schatz, that was another person who was corruptly persuaded to withhold information from federal investigators in that case. And
absent an independently wrongful act, how can we hold a person criminally liable for advising another person to exercise a constitutionally guaranteed right?
Your Honor, the United States would assert that we would certainly concede that when an individual who is advising another in which they don't possess a specific interest in which their criminal liability would be at stake, we draw the distinction there, where in this situation, if we look at Mr. Millstone, the petitioner, merely advising, as was the phrase, merely advising Mr. Reynolds, that rises to the level of corrupt persuasion because Mr. Reynolds' testimony, in particular to federal investigators, would be very relevant in the continued freedom of Mr. Millstone, the petitioner.
Well, I'm troubled by this idea that, all right, if I've got co-conspirators, and that would be corrupt for me to tell him that he should exercise his Fifth Amendment right, strongly suggested, or whatever you want to say, doesn't that also slam right up against the right of free speech?
Your Honor, the vagueness and overbroadness issue regarding the initial answer is no, because that particular issue has been addressed by several circuit courts, in particular United States versus Thompson, in which they immediately disregarded that issue that had come up from both sides, and they argued that within the briefs. That court dismissed that issue, as well as discussions within the Fifth Circuit and Arthur Anderson before it actually made up to the Supreme Court. So the issue of vagueness and overbroadness, that has not necessarily been decided by the circuit courts. And focusing primarily on the Fifth Amendment itself, petitioner asserted that that corruptly persuades should represent an independent unlawful act, and specifically identifying bribery or suborning perjury. However, the United States would suggest that would very much limit the amount of crimes that could fall within the statute itself. In particular, that definition would reach conduct that could be prosecuted under other ways. In particular, bribery under Title 18 United States Code, Section 201, or suborning perjury under Title 18 United States, Section 1622. And by limiting it only to those two, in which those examples found their genesis within examples from former Senator Joe Biden, in which he was discussing the amendment in 1988 that added corruptly persuades. He was merely just giving examples in that situation. And the legislative history is very clear that the purpose of this statute is to protect victims and witnesses. And it also now reaches potential victims and potential witnesses, and making sure that the administration of justice is not impaired and that criminals are not obstructing justice by corruptly persuading others, such as the petitioner did with Mr. Reynolds. In fact, if we look at the creation of this statute in 1982, it originated out of the original obstruction of justice.
My problem with the obstruction of justice argument is the net effect of a person refusing to implicate themselves in a crime is always going to be somewhat obstruction of justice. Anytime a person asserts the Fifth Amendment right, by the nature of asserting the right and refusing to implicate themselves and give information or aid the government in investigation, they're obstructing justice. So that's always going to be the effect of asserting the Fifth Amendment right.
Absolutely, Your Honor.
So how is it any different in this case where, yes, okay, there was the investigation would be obstructed if he had held to it and asserted his Fifth Amendment right? I don't see the distinction. It's all that's the effect will always be, as you call it, an obstruction of justice.
Your Honor, considering the structure of Section 1512b3, the second mens rea, the specific intent in which it's with the intent to hinder a federal investigation, as Your Honor pointed out, pleading the Fifth Amendment, taking the Fifth Amendment would inherently fall aground with the intent to hinder a federal investigation. But we need to look at the first part of it, in which one knowingly, corruptly persuades another to withhold that information. And in this situation where Mr. Millstone...
By that definition, if he hires a lawyer and the lawyer tells him, don't talk to anybody, assert your Fifth Amendment right, then the lawyer runs afoul of the statute under that construction.
Not necessarily, Your Honor, because Section 15, Title 18, United States Code, Section 1515C, in particular, carves out an exception for attorney-client privilege. And only if that attorney was implicated as a co-conspirator in that situation would they run afoul of Section 1512b3. But if Congress wanted to create an exception along the lines of the Fifth Amendment, such as what they did with the attorney-client privilege, then they would have done so. And considering that in 15...
Do you think that Congress thought to themselves, we need to carve out an exception for the Fifth Amendment? I mean, it's in the Constitution. Why would we need to carve out an exception for a constitutionally guaranteed right?
Well, Your Honor, under the case law from Section 1503, under which numerous courts found that in situations like this, where one would corruptly persuade another or corruptly endeavor another individual to utilize or plead the Fifth Amendment in similar situations, much like what we have here today, under 1503, courts have found that to be a violation. And nothing in the history of Section 1512 demonstrates that the Congress intended to go any further from what 1503 stated. And considering the fact that we are to assume that Congress was aware of judicial interpretations of certain statutory language, that we would have to assume that they were well aware of the 1503 judicial interpretations of corruptly in context of the Fifth Amendment. And they certainly would have provided a provision that could have protected individuals such as Mr. Millstone. However, Congress did not do that. And the legislative intent goes as far as showing that Section 1503 was the inspiration for 1512. And Congress has repeatedly, over the course of, since 1982, expanded 1512 for the protection of witnesses and victims. And it does not make sense to adopt the petitioner's definition and interpretation of the statute and assume that Congress is trying to narrow it further when they're trying to create protections for victims and witnesses. Your Honors, even in the Second Circuit, as in the United States versus Kaplan, that case in particular actually came after Arthur Anderson, in which that court analyzed the language of Arthur Anderson and found that the consciousness of wrongdoing language that was proposed by this court in Arthur Anderson was very much in line with the motivated by improper purpose language. And they found that the defendant in that case violated 1512 under the ambit of motivated by an improper purpose.
How does the application of the statute is under your construction in this instance serve the stated goals of protecting victims and witnesses in this case?
Your Honor, it goes as far as looking at Mr. Reynolds. Although he may be a person that's very much involved in the organizational structure of Securitech, he is also a potential witness. And even one as a co-conspirator, the purpose of these laws are to protect these potential witnesses. Even if we look at conspirators themselves, they deserve even more protection, since they possess information that would be even more exclusive than we would find from normal witnesses.
But isn't that what the Fifth Amendment does as well? It provides him protection that if he doesn't want to talk to you, he doesn't have to.
Absolutely, Your Honor. And
so I'm not seeing where there's, especially in this instance where he's a co-defendant or a potential defendant in a criminal matter, where the Fifth Amendment isn't adequate protection enough, and now we're saying, well, but there's additional protection from the tampering statute.
Your Honor, Mr. Reynolds is certainly entitled to his Fifth Amendment right, whether he was encouraged by Mr. Millstone or not. And the Fifth Amendment is tied to the individual and not the information that person protects. And here we're seeing Mr. Millstone trying to utilize and possible violations of standing issues that are not an issue in this case. But Mr. Millstone is trying to take advantage of Mr. Reynolds' Fifth Amendment rights to protect information to come out that could implicate him in this crime of violating the CWA. And in fact, even within the statute itself, Section 1512 F2 states that information itself is free from the claim of privilege. And if we were to look at this, the important inquiry in this case should be that whether the defendant acted corruptly, not whether the target of such corruption could legally withhold his information. And here, the distinction, Your Honor, although Mr. Reynolds does possess that Fifth Amendment right, as does Mr. Millstone possess a Fifth Amendment right for his own information, but by corruptly persuading him, knowingly corruptly persuading him, we are seeing a violation of Section 1512B3 that falls underneath the case law from the Second Circuit and the 11th Circuit, as well as how the 14th Circuit interpreted this case. Your Honors, looking at in particular, Your Honor, if we were to utilize the petitioner's definition when it comes to whether we should utilize a heightened culpability, the United States government would certainly concede that if the improper purpose was a simple intent to hinder an investigation, as seen in Farrell or the like, that would render the Second Circuit's interpretation surplusage, as the petitioner certainly contended. However, if we are to look at as an understanding of corruptly as motivated by an improper purpose with the intent to persuade the right holder to utilize that privilege, that would be a violation of 1512. And it's that interpretation that we see from the Second Circuit, the 11th Circuit, and the 14th Circuit. And even if we look at United States versus Doss in the 9th Circuit, in that case where they had two different situations where the defendant in that case was charged with multiple situations where he was running a prostitution ring and he encouraged his wife to utilize the marital privilege. The United States certainly recognizes and concedes that there was a marital privilege in that case. However, another charge that he faced was him tampering with a witness in which he encouraged one of his prostitutes, part of that ring, that if she were to testify, it would be bad for her. And the 9th Circuit found in that situation that Mr. Doss, the defendant in that case, was guilty of witness tampering there, although they drew the distinction from there with the marital privilege where it was already drawn the line.
Well, we don't have that kind of threatening in this case, do we? I mean, I've looked at what he said, and it doesn't seem to me that there's threats of consequences if he doesn't refuse to talk.
Well, Your Honor, if we look at the context of that conversation itself, Mr. Millstone angrily scolded him and told him that you're not going to pin this on me, and even reminded him that it was they're investigating your stupid gas guzzler.
Right, but I mean, I don't see any threat of harm, any threat of violence, in this statement, at least not in the record that I see.
Well, Your Honor, that certainly as petitioner noted, that there was no overt threat or intimidation, but there was corrupt persuasion along the line of United States versus Schatz. Your Honors, and it's for these reasons that the United States government respectfully requests this court to affirm the 14th Circuit's decision. Thank you.